Good morning, Your Honor.
Good morning, Mr. Pujol. Mr. Tinker, I see you've been brought into the courtroom. So we are ready when you are. You may proceed, Mr. Pujol.
Thank you, Your Honor. May it please the court. Your Honor, I'd like to reserve 5 minutes for rebuttal.
Very good.
My argument.
You may proceed. I'll let you know when you get to that point in the argument.
Thank you. Your Honors, we're here today to address a very serious issue that's been actually growing in the insurance industry and first-party cases with appraisal, and that is with the notice to insurers about their mediation rights. In this particular case, the main issue is going to be whether the client, the insured, received, that's the ultimate issue, whether she received the notice. But it's not so much as opposing counsel or citizens puts it in their answer brief, that we are simply denying having received the notice. We do deny having received the notice, but that citizens did not comply with their condition precedent under the statute, which is statute 627.
Counsel, did you preserve these other issues in the trial court below? It appears that all you did is basically object to receipt.
Yes, sir. This issue was specifically reserved when co-counsel Rick Diaz was the trial counsel, and he argued to the court that he wasn't arguing that the documents were inauthentic. He wasn't saying that they were hearsay, that they weren't properly identified. He was saying that the court failed to take into account business practices, the rules for business practices, to establish the mailing, rebuttable presumption of mailing. There was an affidavit by Mr. Osborne.
Well, okay, go ahead.
By Mr. Osborne. That was the only evidence of bringing the documents in, and that's an authenticity argument.
Well, I understand the arguments, and I understand some of the things you're saying. My question is, we are an error-correcting court. All we are empowered to do is correct a mistake made by the trial judge in making a ruling. And as I read this transcript, and I've read the briefs in this case, the only challenge to this entire situation was your client said, I didn't receive it. I didn't see any challenges to any other part of this process. So as opposed to telling me what your arguments are, point to me in the record where the challenge was made to preserve this issue, please.
Absolutely, Your Honor. And you can find it. I found it most easily rather than going through the entire record. Counsel Citizens was kind enough to submit it. And if you look at page 5, in the middle, it's the transcript is quoted. Mr. Diaz, counsel for Ms. Leone, states, we submitted the 2 affidavits, one from the insured, one from the public adjuster, saying that no such mediation notice was ever received. So this we think is an evidentiary hearing where there has to be some showing that this was actually sent out by certified mail, which is one of the tests, is one of the ways to establish a presumption. I'll get to the other 2 if you want me to do it now.
Is that the closest that you've got to the specific argument that Judge Morris was talking about? Is that the closest you've got as far as where it was raised below?
No, sir. The next paragraph goes on to say, I am not proffering that the documents provided by counsel are not legitimate correspondence from citizens. What I'm saying is that there's no chain of custody that's been established by Mr. Osborne's affidavit with regard to receipt. Just because you mail something doesn't mean that it's received, and that's where we're at. And
Well,
that's why
that's the receipt argument. I mean, that's the only argument you've really made below.
it's both. It is that we didn't receive it, but he's saying that he's not arguing the legitimacy of those documents being citizens' documents. And in the case law that I cited, especially in the reply brief, you'll see that just because a document is authenticated doesn't mean that it was mailed out. And that's the ruling of this court as of 4 months ago.
But let me ask you, as long as you've raised your reply brief, let me ask you something. In your reply brief, you challenge whether citizens raise the issue of American integrity versus Gainey as being controlling in this case. You've taken the position that argument was not raised below. And clearly it was. The record, the transcript clearly indicates it was raised below and argued. So when I read your reply brief to basically, pitch your tent on that battleground, it wasn't raised below. And then I do just a casual look at the transcript and see it clearly was raised below. Why would you make an argument like that?
I did make that argument because citizens made that argument as an alternative throwaway argument, and they cited the case, but they didn't develop why Gainey applies or shouldn't apply. Of course.
Let me get this straight, counsel. So you want to call a strike zone for their preservation that's about that big, but when it's your issue on appeal, you want it to cover the gambit of anything that you brought in your brief.
No, sir. And I'll address Gainey, and I did address Gainey in I believe the last section of my reply brief. My point was that Gainey wasn't fully developed, and that wasn't the primary goal. So at the hearing,
well, your reply brief says it wasn't raised. Period. Not raised, not mentioned. Nobody even was thinking about it, is basically the thrust of your reply brief. So what are we supposed to make of an argument like that? I mean, what should we think about the rest of your argument when you blatantly have put something in a reply brief that is not true?
Well, because it was more of the prematureness of the case. That's what wasn't brought up in the underlying hearing, that the case was premature. And that's the gist of Gainey and why it doesn't apply in this case.
Well, I respect that you don't think it applies, and that's not really the focus of what I've said, but I've made my point. And I was hoping you'd say, gee, Judge, I made a mistake. I'm sorry, I shouldn't have said that. That's what I was hoping for, but I didn't get that. So go ahead, move on. I'll leave you alone now. Make your argument.
Okay. So, well, going back to the argument of why 627-70-15 applies is because the insurer is under a duty at section 2 of that statute and it says the insurer shall notify. It's their responsibility to notify. And again, citing from counsel's, because I believe that's, even more evidence of our position. This is the court stating, the court at page 6 of the answer brief, understood, the court is not inclined to interpret the word notify as the plaintiff's requesting or request. Notify means send out. That's where we believe the court erred because
Mr. Pujol, do you have any case law that supports that argument? Because there is a series of cases that specifies that when notice is required, all that is required is the sending of notice, because the sender can't control the receipt or the claimed lack of receipt by the recipient. So is there any case that says notice has to be established as having been received by your client?
It's not notice having been received. It's the preliminary step that the party charged with providing notice establishes that as the condition precedent. And the first
But your focus in the trial court and in your brief has been whether the insurance company proved that your client received notice. In fact, doesn't seem to be what the law requires. It requires they prove they provided notice, which is by sending notice.
Correct. Correct.
So what am I missing? What am I missing in this?
Right. What it is that ultimately we're saying that we didn't receive it. But before that, you're absolutely right that that citizens has to prove that they mailed or served notice. And the first case is you ask for cases that are right on point, and these have to do with mortgage acceleration clauses where the mortgagee is required to give notice. It's the same standard. They're required to give notice.
So the objection that you failed to make in the trial court is that the affidavit that the insurance company provided did not establish the sending of the notice.
Well, we say that Mr. Diaz did make that objection. He was saying that there's no
The
evidence.
objection was authenticity. The objection was authenticity. There was no motion to strike the affidavit. There was no challenge to the sufficiency of the language in the affidavit, was there?
Yes. When Mr. Diaz states that there has been, that the affidavit of Mr. Osborne, or the testimony of Mr. Osborne, doesn't rise to the level of establishing that there has been a mailing. And he states that that's
put me again. I'm looking at the transcript right now. What page is that argument?
Well, I was getting it from well, there's one instance at the appendix 17.
No,
20.
give me the page number of the transcript, because that's what I'm looking at.
Okay. Just give me a minute.
Actually, if you've got the appendix page number, I can find it that way.
Appendix page number 17, 20, 22 to 23.
1720. I'm sorry, what was that?
Page 17.
So Mr. Diaz talks about the plaintiff's position is not an interpretive one of statutory. We submitted 2 affidavits from the insured and from the public adjuster. American Integrity case that they cite as controlling. We asked the court for an evidentiary hearing, and then the court turns to Ms. Young. So is it later? Have I missed it?
Well, Mr. Diaz starts at line 24 on page 19. Well, I'm on the wrong page. I'm sorry. 17, record 19. Make sure who's talking.
Well, page 20 at the top, it says there's no chain of custody that's been established by the affidavit with regard to receipt. Just because you mail something doesn't mean it's received. And I don't have it right in front of me, but my recollection is that he also said he's not challenging whether it was mailed, he's challenging the receipt. So let's set that aside for the moment. Let's go to the Gainey case. Tell me why the Gainey case does not specifically control the outcome here.
Okay, because the Gainey case involved an investigation that was going on. The Gainey case involved a payment where it wasn't the payment accompanying letter or EOB, explanation of benefits, didn't say that the investigation was complete. Right? In fact, there was ongoing negotiations with the plaintiff's counsel, the homeowner's counsel, and he stated that he asked for the payment to be treated as partial payment. In response, the insurance company asked for a proof of loss. And so they're at Ngani, they're still trying to investigate, find out where the differences are. Here, that's different. And we have at record page 154 is the payment letter.
And Mr. Pujol, that's the 15-minute warning. You are free to go on and use your time in rebuttal, or you can reserve.
I'll just use another minute, Your Honor. At page 154, the letter from citizens states that this investigation is complete. And I go at length in my reply brief at how this letter is different than the situation in Ngani. The letter states that the investigation is complete.
The letter states what it states. Counsel, maybe something to think about while your friend on the other side's going is, why does that distinction matter under the lights of your argument?
It matters because the law doesn't require you to do something that is a nullity. And in Ngani, if you filed suit, you violated the preamble, say, to 627, the statute regarding notice of the mediation, because the whole point of the statute is to try to get ADR and clients into a lesser, more familiar, and less adversarial role. But in Ngani, they went right to litigation. Here, the litigation was already on top of us, but I'll reserve the rest.
Very good, Mr. Pujol. You'll have 3 minutes for rebuttal. Mr. Tinker.
Please the court. Good morning, Mark Tinker on behalf of Citizens Property Insurance Company. I will be brief. Hopefully, I know the courts.
Let me ask you a question, Mr. Tinker, if I may. I want to talk about both Ngani and the statutory language, and I just want to make sure that the position of the insurer in reliance on the statute and on the Ngani case is that even if the insurer fails to give notice of the right to mediate and the insured files a lawsuit, not even knowing that mediation might be available, that the statute says it's no longer relevant and the appraisal process can go forward, basically. Is that your position?
As I read the statute, there's really two answers to that. I want to give the preamble first. As you said, the insured files a breach of contract suit without knowing mediation is available. And I think it's important to point out that the contract, the policy itself, advises of the right to mediation. It's right in there. I believe it's record page 81 off of, just from memory, but I can find it exactly if you need it. But as far as the statute, I'm sorry, I interrupted you.
For purposes of my question, I'm curious about the interpretation of the statute, because the statute says you can give notice in the policy or you can give notice when the claim is presented. So assuming for the sake of this argument that we're not paying attention to the policy language, is Ngani and is the statute saying if an insured doesn't even know there's an option of mediation and the insurer doesn't give notice of the option of mediation, mediation's just off the table and the appraisal process is still permitted?
Sort of. The way that you worded it, what the statute says is if the insurer fails to comply, then the requirement to submit to appraisal as a precondition to legal action for breach is gone. So every policy has the suits against us clause saying, here are your duties, your post-loss duties. If you do not comply, you cannot sue us until you've complied with these duties. This statute says if you don't give the notice, then you don't get to rely on that as a coverage defense. You can't blame the insured or use it as a dispute to coverage. saying, you know, this appraisal provision is in there and it blocks you from coverage. So that's the suits against us provision is gone. What the statute does not say is that appraisal is gone altogether, that it deletes appraisal from the policy. And I think that's would be actually contrary to the point of the statute. The statute is one that is meant to basically, as it says, eliminate, you know, the adversarial process, or try to avoid adversarial process. If a lawsuit is filed, there are legion of cases saying that appraisal is less adversarial than litigation is. It's preferred. It's vastly preferred to litigation. So to say, just because you file a lawsuit, now we're not even going to allow you to go to appraisal because we want to avoid adversarial process doesn't make any sense. So the statute says if you don't give this notice, you can't rely on the suits against us clause as a defense to coverage, but it does not ever say that deletes appraisal from your policy. That'd be contrary to the entire intent of the statute if it did. And to go to part of your question was, how does Gainey apply into it? And I know I'm speaking to two of the three members of the panel that were on Gainey, so I don't really need to describe it to you. But what the court looked at was saying, this is the plain language of the statute. All we do is just interpret it. And the statute says this section is available with respect to claims before commencing litigation. And once litigation is commenced, the section does not apply. There's no point to it anymore. There's no way that the statute can help you avoid an adversarial process if the insured has started the most adversarial process that you can. The insured has filed a lawsuit. So the statute has no purpose at that point. And it would be contrary to the statute to say, well, now we're going to just delete any form of ADR that might be in the policy because this one wasn't complied with. That's not what the statute says. That's not what the court did in Gainey. The court just looked at, here's the plain language of it. This section is available before litigation. If the insured does not comply, they cannot rely on the failure of the insured as a precondition to legal action. So that suits against us, defense to coverage is gone, but it doesn't delete appraisal from the policy at all.
And you have asked, or you raised one other point that I wanted to ask you about. Was the trial court ever told in response to the argument made by the other side that the policy provided the notice language?
I don't recall seeing that in the record, Your Honor, no.
Okay. And was that argued in your brief?
It's a short record and I've read it about 5 times in the past 24 hours and no, I don't recall seeing that in there.
Was that argued in your brief?
No, Your Honor.
Because it seems to me that if notice was given under the statute, that takes care of it one way or the other, doesn't it?
I would agree with you. It's something that I was honestly looking at this morning. And, you know, as far as our purposes, if the court sees it in there and believes that it complies with the statute, then, you know, we fall into the tipsy coachman area. But
of course,
I don't believe that it's relevant because I believe, you know, under Gainey and under the plain language of the statute and what was argued to the judge, as far as all we're talking about is receipt, then I believe any one of those compels affirmance at this point.
Well, the other side does mention mailing in the argument, but I agree it's pretty peripheral of an argument.
He does, and you know, every time that it goes there, there's, you know, I quoted this language a couple times when I was looking at it, is he would say, what we need to do is see if it was received, and that's where we're at, sir. He kept saying that, so he was telling the judge, this is our concern, and not only that, he didn't even say this is a matter of waiver. He said, what we need to do is have an evidentiary hearing on this issue of receipt was the remedy they were asking for. So that was the concern that they presented to Judge Ward. He looked at it, and Judge Silberman, you said, you know, there are cases that saying receipt isn't an issue if it's mailed. That's fine. So Judge Ward was looking at it, and he didn't think that there was an issue with receipt that needed to go any further. Unless the panel has any other questions, I'd yield the rest of my time.
Very good. Thank you, Mr. Tinker. Mr. Pujol.
Yes, and thank you. May I have the audacity to contradict counsel on one issue? He's saying that the statute doesn't make the appraisal go away if their notice isn't given. That's true, but it also says that it's now up to the plaintiff whether he wants to submit to appraisal. And that's subsection 7, and say the policyholder is not required to submit or participate in any contractual loss appraisal process. So if the insured wants to do appraisal, then sure, the appraisal process may go forward. But if he chooses not to, then the statute itself precludes it because he's under no obligation to do so anymore. The last thing I want to point out is the affidavit of Mr. Osborne, where he has absolutely no evidence that he has knowledge of. And let me give you the standard, saying that the fact a document is drafted is insufficient in itself to establish that it was mailed. This is the second DCA's case, Allen versus Wilmington Trust. And it states that instead, mailing must be proven by producing additional evidence, such as proof of regular business practice, an affidavit swearing that the letter was mailed, or return of receipt. None of those three requirements are in the affidavit of Mr. Osborne. The routine business practices, he has to have knowledge of the mailing system. He has to have knowledge of the personal mailing system, or personal knowledge of the company's general mailing practice of letters. That's in the statute, or in that case, Mace versus M&T Bank, 292 Southern 2nd, 1215, second DCA case in March, says exactly the same thing. A lender's obligation to give notice of default in accord with these provisions is a condition precedent. And that's why while we have argued that we didn't receive it, the first step is, did the carrier prove or establish a prima facie case of its condition precedent that it mailed it, that it gave notice. The M&T case states that that to do the job for the presumption of mailing to come up, there's three things. One is the testimony of a witness or witness with personal knowledge of the mailing system. Look through the affidavit of Mr. Osborne. There's nothing like that in there. Second is the evidence that the organization responsible for mailing the letter had a routine practice with respect to mailing letters of that type, from which a court can infer that the routine practice and the letter was mailed. Again,
Mr. Control, your time has concluded, but you can take 15 seconds to wrap up.
Again, there's nothing in Mr. Osborne's affidavit about that. And the third way to satisfy the condition precedent of giving notice is a return of such a thing as a return receipt or a log entry generated upon mailing.
Very good. Thank you very much, Mr. Pujol, Mr. Tinker. That concludes the case of Leon versus Citizens. The next case that will be called is Scott versus Scott.
Thank you for your time, Your Honors.
Thank you.